All right, now I'd like to welcome to the show Patrick Hedger, Director of Policy at NetChoice. Welcome back to Free the Economy, Patrick.
Thank you for having me.
So, regular listeners will, of course, remember Patrick from episode 12, all the way back in March of 2023, when the two of us talked about consumer welfare and antitrust enforcement and big tech, big business, and whatnot. This distinguished man is only our second ever returning guest, next to my own distinguished colleague, Ian Murray. And now that you're with a new organization, why don't you give us, just to start off with, the short pitch for NetChoice? What is it? What do you do? Why is it great?
Yeah, absolutely. We are a trade association that works to keep the internet safe for free enterprise and free expression. So we are ardent defenders of capitalism, and we are defenders of free speech as well in the First Amendment. And we are a principle-based trade association. So while we represent several major technology companies of various sizes in the United States, we have our guiding philosophy is our principles. Again, couched in free enterprise and free expression.
All right, fantastic. Now, so there's a lot of legal wrangling, legal challenges going on in the tech space with big tech companies and big government. In some cases, small, maybe not so big governments, the case of state governments. But the number one case that y'all seem to be fighting and tracking right now, it seems to me the number one, is the Biden administration's Department of Justice and Google. It's tough to get much bigger than Google. So the feds at this point have accused Google of all sorts of anti-competitive things, and they are trying to get a court to basically break up the entire company as a remedy for the stuff that Google has supposedly done. And that one seems a little extreme to me, as a court-ordered remedies go. So in fact, a wise man recently said, quote, "The proposed remedies create staggering, perverse incentives and other restrictions that will harm innovation in the evolving search marketplace, AI, and broader tech sector." End quote. We won't disclose who said that, but tell us, where are we at with this DOJ versus Google case, and what's coming next?
Yeah, well, I think I agree with those words, and they sound very familiar. Where we're at right now, and Google is really the first of sort of the big cases that has gone to trial and passed through trial, and we've had a verdict, and now we're in the remedies portion of the trial. And of course, we have some cases. We just heard that the FTC's case against Meta will be heard in April next year, and we're in the process right now of a case, the DOJ's case against Apple. And then we've got forthcoming cases against Amazon as well. But Google is sort of the first one out of the gate that's kind of gone through the major trial portion. And what was found is that you have to understand that in American antitrust law, simply having large market share or a monopoly is not illegal. You have to be also found to have engaged in conduct that is illegal because with that market share. And what the court found was that Judge Mehta found that Google does have an illegal monopoly in the search marketplace. But of course that's going to be appealed. Google is appealing that decision, but right now we are in the portion of the trial where the DOJ has proposed remedies for that. Uh, Finding and the finding of having that monopoly, the core of the case is related to exclusive deals to have Google search placed as the default on um, browsers and mobile devices to be the default search engine on those devices. And so that's really the core of the case. It was actually a pretty narrow finding, even by Judge Mehta. Judge Mehta explicitly said, look, Google did not get to its size and market share through illegal conduct. It got there by being a relentless innovator. And so the first case, because there's another case that's ongoing right now um, about the ad tech marketplace around Google. This one that we're talking about right now is specifically tailored to those deals that Google has with Mozilla, with Apple about placing Google as the default search engine. And so while the finding was very, very narrow by Judge Mehta, and again, it's being appealed, the DOJ has come in and said, well, we're just going to break apart Google. The first request is to spin off Chrome, which is the most popular web browser by far. Um, and then potentially in 5 years, if the search marketplace doesn't improve to the liking of the government, remains to be seen what that is. There could be a request for Google to spin off Android, its mobile operating system as well. So this is a pretty substantial breakup of the company that the DOJ is asking for, and it's really kind of it seems like they're throwing everything against the wall to see what sticks because again the finding against Google by Judge Mehta was incredibly narrow.
So, you know, this, makes me wonder what standard we're applying here. The question is, if the holding is that Google is too much of the search market, how much is too much? And how will we know when it's no longer too much? Like you said, there's sort of this potential 5-year look back, which makes me wonder whether this judge will, still be supervising the conduct of Google when he's 107 years old. But if we say 5 years from now, we say, well, what's the search market look like in 5 years? And if it goes from, X percent to Y percent, what are those numbers? Like, what do we have to get to? Is there any objective standard, or is it just sort of a judge looking at a report filed by the future Department of Justice going, that seems fine, or that doesn't seem quite right. Like that seems like a little too vibes based for breaking up $1 trillion company.
Right, and it's important again that the size of Google is not what's the illegal here, right? It's the having that size and then presumably engaging in these distribution agreements is what the court has initially found to be illegal. And so to say that we're going to condition all of these other things on some sort of arbitrary size threshold doesn't seem quite right. I mean, it seems like the 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 easiest thing to do would be to say we have an injunction against Google from making these deals going forward. Again, this is all pending appeal, but the DOJ has just gone so far and is basically creating all of these remedies requests that would be very hard for Google to satisfy and really leave consumers in the back seat, right? The perverse incentive that's here is that for Google to maintain ownership of Android going forward, they have to lose market share, presumably in search. But the judge has said that Google has the market share that it does in search because it has been a relentless innovator and it's continued to create and produce the best search engine. That's why it has the market share that it has. So presumably the only answer for Google is to essentially nerf or degrade their search product in hopes that they get to keep Android in 5 years. That I don't understand how that supposedly helps consumers. And then you have the other side of the equation where how does spinning off Android make it a more effective competitor in the marketplace for mobile operating systems and mobile devices when you have at the same time in a different courtroom the same Department of Justice arguing that Apple itself is a monopoly in the mobile device system, operating system, mobile device marketplace. And so the DOJ is really trying to have its cake and eat it too here. It's trying to say that Apple has an illegal monopoly and then weaken Apple's greatest competitor. None of this makes sense, and it seems like as the Biden administration winds down, they're trying to throw again as much against the wall to see what sticks in hopes of trying to get some sort of legacy setting decision.
Yeah, if they can only ruin one of America's most successful companies, then that's what they'll hope to go out with. Uh, so, the Google case is up at the federal level, obviously, but we've got plenty of tech lawsuits at the state level as well. So we've got California. They've got a dispute over what they call SB 976, state law that will force companies to create barriers to California's accessing lawful information online. And that has to do with you know, forcing companies to try and identify who's using their services online. Um, and the proponents of regulating internet companies that way say it's about protecting kids. Won't someone please think of the children? Uh, but NetChoice and plenty of other critics say that's what California is doing is not the right way to go. So what is it, Patrick? Do you want to protect the children or not?
So obviously, all of these laws and rules and regulations designed to try and protect kids online are very well intended. And the issue is that intent is never enough, right? You have to look at outcomes. And so there's a couple problems overall with these types of rules and regulations, whether you see them at the federal level or the state level. At the state level, there's an issue of trying to regulate the internet, which is fundamentally an interstate service. If anything is interstate commerce, it's the World Wide Web. Trying to regulate that at the state level can cause a lot of problems. We're even seeing it at the international level as well, where you have European Union regulations that are conflicting with standards and expectations in American law. And you've got a situation where some American companies are no longer offering new services in the European Union because they don't want to comply. Imagine that in the United States. Imagine if your internet works differently in one state versus another. That's a really difficult thing to comply with. And, some of the bigger companies perhaps have the resources to be able to do that. But really, if you think about the startup and creator economy, trying to comply with a patchwork of perhaps 50 different rules and regulations related to online services is impossible. And so you end up also having sort of a federalism issue where companies are going to implement the highest level of regulation in order to ensure that they comply with everything else. And so you've got the issue of certain large states that are basically effectively legislating and regulating for the rest of the country. So that's one big problem.
And
Over,
by which we mean California.
overall, the other issue with some of these approaches to try and protect kids online, again, very well intended, you essentially have two buckets of problems. The first is that the definition of what is harmful to a child that can vary quite a bit. And it can sometimes sweep up perfectly lawful content, right? There's a lot of talk about content that can be distressing or cause anxiety or body image issues. And that could range from fitness videos to diet videos. Those things may create body image issues for kids, but those things are perfectly legal speech. And then you also certainly have some other legal speech that's on the fringe that's always been up for the parents to decide. If you think about some of the other kinds of content that are out there, whether it's video games or it's movies, those rating systems are voluntary rating systems to kind of give parents the ultimate decision on whether or not their kids are going to be exposed to that content. And trying to legislate this or regulate this at the governmental level inherently subjective values is going to lead to essentially censorship by proxy. So you're going to have companies that are going to be censoring content because they want to be in compliance with as be as broadly in compliance with these types of regulations as possible. And so you end up seeing protected speech getting silenced, and that's the big problem. The other bucket is the privacy issues, right? How do you determine who is and who is not above 18 without gathering even more personal information about that user. And there are a whole host of privacy issues there. And we've seen those kind of pitfalls where you create essentially honeypots of data that will be breached. And that's a big problem, especially when we're talking about data related to kids.
Well, if the premise in the future is that every one of these regulated websites or platforms, if they host any content that might be accessed by children in order to decide who is and who is not a child, because not every 14-year-old on the internet always tells the truth. You need, say, a picture of everyone's ID, right? Everyone's got to, scan their like driver's license in to prove they're over 18. Well, then you now have a database full of everyone's driver's licenses, which amazingly data pirates and bad guys on the internet might in fact want to hack that database. And if every platform or every site that has any content like this has to have one of those databases. Well, that's like a bunch of barely locked bank vaults just spread across the country because the vast majority of those sites and platforms are not going to be experts in data security. They're content sites, right?
Yeah, and we've even seen there's a real world example of this. There was a province in Australia that I believe it was New South Wales that uses um, essentially a digital ID tracking system for access to physical venues, right? So the same technological equivalent for going into an adult club or buying alcohol, things like that. And that was breached, and a bunch of IDs for people that visited those places were released onto the dark web. And then you also had a major data breach that impacted basically everybody in the District of Columbia on the DC Health Exchange, where everybody was forced into one health exchange under the Affordable Care Act. And because of that, members of Congress, all sorts of high level folks, and down to low level, down to the average person, right? That data was leaked onto the open web because again, you created such a concentration of sensitive data. So these aren't hypotheticals, right? Hacks happen all the time. I mean, data breaches are a reality. So um, collecting more data than you need and doing so when it's perhaps unconstitutional is a big problem.
That that could also be part of the problem. And again, the question of I was sort of going to get into this, but you already kind of led into it. The idea that the internet is now going to be a state by state specific thing in the United States seems a little silly at best. And like you said, not all of these concerns are hypotheticals. A lot of them things that are already happening. There are already companies, including some adult content companies, which maybe of course, I'm not familiar with them, but some of our listeners may be familiar with some of the adult content companies out there that are already gating off state by state. So there are, states that say, well, if you're going to have, adult type content, adults only type content, then, you have to jump through certain hoops. And those companies have just said, well, then people in that state can't access our servers and we'll be, they're companies like that are, instead of a 50 state company, they're a 37 state company because, they're no longer letting people look at their stuff. And maybe the sort of racy, not safe for work content isn't the most sympathetic example, but that doesn't mean it's not going to be the only example, right? If we have more aggressive state by state regulation of internet platforms and companies, sites, you're going to have more of that splintering up because there will be regulations of all of other kinds. Again, that doesn't have to do with explicit content. There will just be requirements put on companies by states on all sorts of angles, and plenty of companies will just say it's not worth it for us to comply with that state. So guess what? You don't, I hope you liked Amazon Prime because now if you want to keep using it, you're going to have to move across the border to Maryland or Virginia or whatever. And that seems like the wrong path to go down. So, my question is when some of these, it's not unheard of for state laws to get challenged in federal court and for federal courts to, at some point and for various reasons, say, actually, state legislature X, this is not your business. We're striking down your law because this is a federal thing. This is really Congress should be in charge of this. How many of these state laws, because as you pointed out, this seems like a by definition interstate thing. How many of these do you think are just going to get struck down by federal courts by them saying, sorry, Louisiana state legislature, you're stepping outside your bounds?
Yeah, we're seeing a lot of novel approaches these days, so it's hard to predict. We're also trying to educate lawmakers about how can we best protect people online without creating major constitutional problems. And in terms of compliance, right, if there's a concern about concentration in the tech marketplace, whether it's retail or whether it's search or whether it's social media, if you are creating regulatory burdens that are so complicated that you need an army of lawyers to comply with, how does that help competition? How does that help startups? Essentially, what you're doing in trying to regulate the companies that you may have a problem with is you're digging a regulatory moat around them that inhibits their regulatory challengers, right? The startups in the garage somewhere in Silicon Valley that couldn't possibly comply with a patchwork of state regulations. And what's really important to remember is that what makes so many of the services like Amazon and Facebook and Google valuable is scale. They're large. It's network effects. And so if you are, the value of a social media company and advertising on a social media platform is that you've got a lot of different users in a lot of different areas, and you can kind of target your advertisements to those people. There's not a lot of value in a state-based social media platform or only products that are available in your state, right? You want to be able to shop and connect to the widest base possible. And so inherently trying to limit the size and scope of networked businesses is not helpful for consumers.
Yeah, and so we have some of these state regulations in, like we said, in California, it's got SB 976, and then in Florida, we've got HB 3. And what's interesting about this is that, again, these are sort of like, protect the children, verify who's on your platform kind of regulations that you have the state that's really sort of the poster child for left-wing policymaking in modern times, which is California, and then the state which, especially in the past few years, has been the poster child for more right-wing controversial policymaking in Florida. Um, are taking a weirdly similar approach to some of these issues, and it makes me wonder: is this a silver lining that we have bipartisanship and national unity with bad policy from both the red team and the blue team, or what is this teaching us that we're so polarized on so many other topics, but we've got state legislatures both trying to do what we probably think is probably a bad, at least at the very least, a bad way of approaching this protect the kids online version. What are we learning from this?
Yeah, what's challenging is that these a lot of these regulations may seem similar, but it comes down to enforcement. And again, when we're talking about subjective values, right? We're very concerned about a progressive state regulating speech in a progressive way, and a conservative state pushing for the opposite, perhaps. There's a big split in terms of social media regulation, in terms of some one party wants to see more stuff taken down, see more content moderation of certain things, and you tend to see the opposite on the other side. They want certain things moderated, but they want other things left up. And these are decisions that fundamentally the First Amendment says that government shouldn't be making. And so we would hope to see more effort in terms of government using the power that it does appropriately have to educate parents about existing parental controls that exist at all levels of the internet stack, whether it's the website itself, the service itself, the app. At the App Store level, at the device level, at the ISP level, there are parental controls in all those places. That's where the decision making ought to be made, not essentially handing these things over to an attorney general or the trial bar, where these decisions of what is and what is not harmful content are almost impossible to predict.
Yeah, the that's a good example about, or a good point to make about that a facially neutral law, a law that says, well, we shouldn't have inappropriate content on the internet. The people in California versus the people in Florida defining who gets to define what's inappropriate is going to be very different, right? You could see a sort of
Well,
left-wing parent who wouldn't want their kids to see a video of someone firing a gun. That would be unacceptable. But then the conservative parent doesn't want to see their kid, or doesn't want to have their kid see a video of a drag show or whatever, right? Um, and that sort of discretion in the hands of enforcers again, for what is almost entirely what we're talking about here, constitutionally protected speech, uh, again, is not reassuring.
yeah, I mean, I think that gets at the heart of the problem is who is defining harm, right? And we're talking about a lot of cases. There are some things that are objectively bad, and that the First Amendment case law already kind of deals with. But beyond that, I think that's a perfect example, right? I mean, it's taking your kid out to the range and shooting a gun is perfectly legal. And it's perfectly legal to take a video of it and share it with your friends and family. But one state may find that to be harmful, another state may find that to be, a proper, display of Second Amendment rights. So, and all you're creating enormous legal costs as well, all right, for these companies where all of this is getting litigated. Again, these are decisions that government shouldn't have a hand in, and that's ultimately our point.
And one more of these cases I wanted to mention for our gamer friends out there. We've got Google versus Epic Games that has to do with how customers are able to access apps on an app store. And there's a great quote from our good mutual friend Paul Tashke from NetChoice, where he said about that Google versus Epic Games case that quote, America's antitrust laws are designed to protect American consumers, not corporate competitors. Current app ecosystem is fiercely competitive, and competition served Americans well by fostering a market with millions of apps to choose from. Um, one, I'm interested in how or what's the the actual accusation uh, that supposedly there's supposed to be a remedy for in this case, but also doubling down on the principle that Paul mentions, which is that the whole reason we have all these competition laws is to safeguard consumers, not to play favorites with whatever company we like in a marketplace.
Yeah, so at the core of these Epic cases, Epic is the producer of the popular shooting video game Fortnite. Um, is that they want to be able to sell in-game add-ons like a new type of gun or character or whatever. They want to be able to sell those without having to pay for the distribution channels that they have, which is the app stores. And the app stores charge based on scale. And because Fortnite's very popular, it's sort of like a progressive fee structure. Because they are one of the larger apps and user bases, Apple and Google recover their costs with a fee on those transactions that happen on apps that were downloaded through their app stores. And so what they keep calling it a tax, but a tax is, the government's imposed taxes. This is a price, and it's just a price that Epic doesn't like. And so they're trying to get the government essentially to come in and pad their bottom line, and free ride on the sort of security innovations, the marketing costs and development costs that Apple and Google have made in producing their device ecosystems. So that's essentially what's at stake here, and it is very much so the essentially Epic looking for a handout from the government at the cost to Apple and Google and their users.
Oh, so yeah, I mean, uh, uh, you know, I understand that, the people who are running the app stores should be able to, charge a price to people who want to use it like Epic. On the other hand, I do really want to be able to play Fortnite with a Pat Hedger skin. So it's just like me as you just shooting everyone in sight. Um, so as you might have heard, there was recently a election here in the United States, and I've been repeatedly reminded by political advisors on both sides that elections have consequences. And so we are going to have a new president, a new administration coming in because a lot of competition antitrust enforcement comes out of the executive branch at the federal level. You've got the Federal Trade Commission, which is an independent agency, but you've got the Department of Justice, which is very much more directly controlled by the president. Um, what is going to happen when we have Trump administration 2.0? Is the new Trump DOJ going to go easier on these companies? Is there going to be less aggressive antitrust stuff, these big tech cases, which is what you would normally expect in a Republican administration? Or are we in Republican administration bizarro land where the Republicans now also hate big tech? So maybe it'll be even worse, right? Like where are we going to go here?
Yeah, that's a great question. And the best way I can answer it is it's hard to be much worse than the Biden administration. The Biden administration has been sort of the pinnacle of crazy really when it comes to antitrust in the last few years that where there's been just a complete departure from existing and prevailing antitrust precedent that's focused on consumer welfare. I mean, what they are asking for from Google because of a narrow finding against Google related to exclusive dealing, exclusive deals related to being the default search engine. Um, they're seeking a breakup of the entire company and going after services that have nothing to do with the core finding of the case. And you've also seen outside of tech, the Biden administration blocked the Spirit JetBlue merger in hopes of trying to maintain a quantity of competitors in the airline marketplace. But now Spirit has filed for bankruptcy and may not be flying soon. So you end up with the same number of airlines as you would had they merged, except JetBlue is weaker, right? So instead of focusing on quantity or quality of competition, they've been focusing too much on quantity. And again, not focused on protecting competition per se, but protecting competitors, like we're seeing essentially the you know, going after certain companies to favor others in this in similar
Right.
marketplaces. So the consumer has really taken a back seat under the Biden administration. So it's hard to do much worse. We're optimistic that the Trump administration will take a more narrower approach to some of these issues. I mean, the Biden administration's essentially been swinging a hammer in some cases where a scalpel is all that's necessary. And we're hoping that some of the crazier cases that are being pursued, like right now, the Federal Trade Commission, the case they're pursuing against Meta, would look back and say, we're going to unwind mergers of Instagram and WhatsApp that happened over a decade ago. I mean, imagine the kind of, and were explicitly approved by the FTC at the time, by the way. So imagine the kind of chaos that you could create in the economy if something you did that was explicitly approved by a regulator 10 years ago is all of a sudden landing you in hot water. And so ultimately, just the Trump administration's overall approach of America first, wanting American companies to do better and the economy, you know, a stronger focus on the economy. We hope that that necessarily lends to a more focused approach on antitrust versus basically just trying to again throw everything against the wall and see what sticks.
Yeah, finally speaking about America and American companies versus other companies, our international competitors, to the extent they exist, looking at Europe and the EU, which we've had the state level, we've had the federal level, and now we have this sort of like international level. People who are sort of tech industry observers have joked for some time that Europe doesn't really have any big tech companies, and that uh, their competitive advantage is in building rules and bureaucracy to regulate technology instead. That's probably not the kind of innovation we most would like to see, and makes me wonder at what level does this continue to be possible, right? If all the big tech companies are American, or maybe in the future they'll be Chinese or whatever, but they're not European, right? But the European Competition Authority keeps thinking it's up to them to levy billion-dollar fines on these companies. At what point do we just stop saying, do the big companies just say, no, we're not paying that, or no, we're not offering our services anymore? Like you said, there's already the case of some tech companies not offering certain new products or certain new services to European consumers in part for this reason, but are we going to see more of a bifurcation of that? Are big tech companies going to say like, "Sorry, France, you don't get any of this stuff anymore"?
Yeah, I mean, ultimately Europe's got a demographic problem in this, right? Europe's population is not growing to the extent that you see populations growing in Southeast Asia and Sub-Saharan Africa, and those are places that are becoming wealthier as well. And so I think the frontier of the internet, I think, is being built here in the United States, here being built predominantly here in the United States by American companies, but we also have several large Chinese companies as well that are competing in the global ecosystem. And to your point, yes, they're basically Europe's tech sector doesn't register. There are, a few small tech companies here and there, but nothing compared to the Googles and the Amazons and the Metas of the world. And so I think Europe, they can get away with some of this right now because they do have a large, wealthy population, but relative to the rest of the world, as we continue on, that's going to continue to shrink in terms of where the people are and where the wealth is. And so companies aren't going to want to comply with and face not just fines, but some of the fines that are built into European law would bankrupt companies almost instantly. I mean, we are talking not just fines based on the percentage of the money they are making in Europe, but fines based on global revenue, right?
Mm-hmm.
10% of global revenue. No company can afford that. I don't care how many trillions of dollars they're worth. And so Europe can only push it so much. And as we've talked about, we're already seeing examples where American companies are saying, we're not going to do this anymore. We're not going to offer our new services in Europe because we don't know what you're going to do to us. And at some point, though, the administration is going to have to get involved. Right now, unfortunately, under the Biden administration's been helping Europe do this stuff. American taxpayers have been paying for American officials to go over and help Europeans with the implementation of their Digital Markets Act and Digital Services Act, where a lot of these fines are coming from. That's got to stop because even outside of internet technology, if you look at the Illumia Grail merger, even though there was no nexus to the European Union for either of those companies, they got hit with an enormous fine for going through with what the Europeans found to be an illegal merger, right? Can you imagine that? I mean, imagine companies that have no footprint really in any way in the European Union that are merging here in the U.S. market and then are getting fined from Brussels. That can't continue to happen. And so we hope that the new Trump administration will take a more aggressive approach to that. Because if you want to talk about getting a raw deal in international trade, that's as bad as it gets.
Yeah, I mean, from now on, I'm going to start regulating when any Swiss dairy farm buys another Swiss dairy farm.
Right.
Just because I don't think they should be buying out those dairy farms like that. It's just unreasonable. Um,
That's a cheesy example.
so, Patrick, thank you so much for taking through all of these many complicated cases. It is dizzying and sometimes annoying and confusing what the both feds and the state people are trying to do to our beloved American tech companies. But it becomes much easier to understand when a smart and patient gentleman such as yourself is here to explain it to us.
Well, it's been
S-
a pleasure.
So before we go, make sure everyone knows where to find you and your stuff online on social media and where do they look?
Yeah, absolutely. You can find me on X at Pat_Hedger. You can find us at netchoice.org. That's where we publish a lot of our content. And then also follow at NetChoice on X as well, where we publish a lot of our blogs as well. But look for us, and we're constantly weighing in and talking about how to ensure that America leads the global technology space, again, in terms of free expression and free enterprise. And when we talk about the global competition that you mentioned, we want the future of the internet to be built on American values, and that's ultimately our goal.
Excellent. And also, if you are a federal a clerk in a federal court, you may also see some of their briefs come across your desk. All right. Well, thank you very much for being with us, Bad.
Thank you.